President Trump calling it the biggest deregulatory action. The Environmental Protection Agency has reversed a landmark decision that fights climate change and regulates greenhouse gas emissions from vehicles and power plants.
It's called the Endangerment Finding. It's a landmark scientific determination that planet-warming pollution from fossil fuels endangers human health. And since 2009, it's formed the bedrock for the EPA's ability to regulate greenhouse gas emissions.
President Trump's insistence that climate change is a hoax is effectively signed into U.S. policy. And it's a signature that essentially puts EPA Administrator Lee Zeldin out of a job.
Under the process just completed by the EPA, we are officially terminating the so-called endangerment finding.
You are listening to Climate Court Voices, a podcast where we speak with the individuals leading crucial climate lawsuits and championing environmental justice efforts worldwide. In this episode, we're diving into the Trump administration's move to dismantle a cornerstone of American environmental law, the Endangerment Finding. Since 2009, this legal pillar has compelled the Environmental Protection Agency, the EPA, to treat carbon pollution as a threat to public health. Now, their mandate is gone. The move has triggered a firestorm of legal challenges and left the future of US air quality in limbo. Today, we're joined by environmental attorney Noah Perch-Aher to discuss what happens to pollution control when the bedrock of regulation is wiped away. To understand what the endangerment finding is, we must take a step back to 2007, when a Supreme Court ruling changed how the US viewed pollution regulation.
Good morning, and thank you all very much for being here today. Today's hearing will focus on the aftermath of the landmark Supreme Court decision in Massachusetts versus EPA, both within the Bush administration and within Congress. In 1998, in response to an inquiry by then Representative Tom DeLay, the Clinton administration's Environmental Protection Agency said that it believed that the Clean Air Act provided it with the authority to regulate carbon dioxide. 1 year later, a group of environmental and other advocacy organizations petitioned the EPA to use this authority to set greenhouse gas standards for cars. But it wasn't until 2003, when the Bush administration had already embarked on a course of denial, delay, and dismissal of the risks of climate change and the need to address it, that the EPA repudiated the Clinton administration's conclusion that carbon dioxide was a pollutant that could be regulated and denied the petition. That petition became the case known as Massachusetts versus EPA.
The voice you're hearing is Edward Markey, a Democrat known for progressive policies and a leading voice on climate change in the US Congress, who served as the US representative for Massachusetts' 7th Congressional District from 1976 to 2013. In June 2007, 2 months after the Massachusetts v. EPA Supreme Court ruling, the House Select Committee held a hearing, led by Markey, exploring the ruling's implications. Until the 2007 ruling, the Bush administration continued to dismiss what by then was already undisputable scientific evidence of the dangers of carbon dioxide for human health and the planet, asserting that it lacked authority to regulate carbon dioxide and that voluntary regulations would be sufficient. The Supreme Court ruling changed that. In a 5-4 vote, the justices ruled that under the plain meaning of the Clean Air Act, carbon dioxide is a pollutant. What that meant was that the EPA now had the duty to regulate this pollutant, as long as it could determine that emissions of carbon dioxide endanger public health and welfare.
That decision was important because, number one, it found that at least states have standing to sue when it comes to climate change issues. It found that greenhouse gases, including carbon dioxide, are pollutants under the Clean Air Act. And it said that the EPA cannot decline to regulate based just on policy issues. There's a statutory duty to evaluate under a specific provision of the Clean Air Act whether greenhouse gases cause or contribute pollution which may reasonably be anticipated to endanger public health or the welfare with respect to new motor vehicles. So basically, you had the Supreme Court back in 2007 telling the EPA, look, this is an air pollutant. Okay, we've looked at the text of the Clean Air Act, and carbon dioxide, greenhouse gases are air pollutants. And there's this statutory duty to decide whether there's, endangerment to the public health or welfare. And now you need to go through a process. You need to go through a reasoned regulatory process to come up with a scientific justification for regulating or not these pollutants. And so that set into motion the process for adjudicating or deciding the endangerment issue.
The process under the Obama administration led in 2009 to what became known as the Greenhouse Gas Endangerment Finding. The EPA found that the current and projected concentrations of 6 well-mixed greenhouse gases in the atmosphere, including the 3 most known ones, carbon dioxide, methane, and nitrous oxide, threatened the public health and welfare of current and future generations. The EPA also found that the combined emissions of these greenhouse gases from new motor vehicles and new motor vehicle engines contribute to the greenhouse gas pollution that threatens public health and welfare. These findings per se did not directly translate into any requirement on industry or other entities, but they became a prerequisite for implementing greenhouse gas emission standards for vehicles and other sectors.
That became the legal foundation for most federal climate change regulation under the Clean Air Act. And there was a sort of a cascading impact. You quickly get greenhouse gas standards for cars and trucks. It led to a power plant carbon dioxide rule, the Clean Power Plan. It led to oil and methane regulations. And it led to some greenhouse gas permitting under the Clean Air Act, something called a tailoring rule. Interestingly, many of these programs, probably all of them, have been challenged, and some of them have been subject to some modification by courts. But what you saw was that the endangerment finding did create this cascading impact of regulation of climate change by the EPA under the Clean Air Act. So it was this foundational trigger that sort of continued over time to create new programs for regulating greenhouse gases. And I personally, as I look back at it, I think it was sort of groundbreaking because there was so much congressional stalemate over climate change legislation. And this was a way to break through that. And it's also something that I think was important in that the way the court decided Mass v. EPA, and then following the endangerment finding, this became sort of a fixed statutory duty, really, and something that didn't just change with, political change and political wins. It became part of the program, as it were. And that was 20 years ago. I also think that had an impact on how the federal government viewed climate change and other administrative agencies, how they considered impacts of climate-related risk. You saw different agencies incorporating that into their decision-making process. And of course, there's been an impact on industry as they've complied with these programs and relied on these programs in terms of making changes in their business and production and so forth. So there's been, it's been a pretty big impact.
For nearly 2 decades, the endangerment finding was the legal engine behind US climate action. It wasn't just a policy, it was a mandate that said the government must act. But this all changed this February.
Hello, everybody. Hi. This is a big one. If you're into environment, this is about as big as it gets, they tell me. Under the process just completed by the EPA, we are officially terminating the so-called endangerment finding, a disastrous Obama-era policy that severely damaged the American auto industry and massively drove up prices for American consumers. Prices went up incredibly for a worse product. This determination had no basis, in fact, had none whatsoever, and it had no basis in law. On the contrary, over the generations, fossil fuels have saved millions of lives and lifted billions of people out of poverty and all over the world. And you see it with the blackouts all over where they don't use it, where they went to wind, intermittent wind, which is weak and ineffective and very, very costly, most costly energy there is.
There is a lot to unpack here. And while that's not the focus of this episode, let's just clarify before moving on that wind energy is now generally cheaper than fossil fuels in most of the world, with onshore wind costs declining over 68% and offshore wind costs declining over 59% over the last decade, according to Harvard data. But back to the automotive industry. The Trump administration and supporters of the repeal say the findings repeal would make cars cheaper, bringing down costs for automakers by some $2,400 per vehicle. Environmental groups are skeptical of the potential cost savings being touted by Trump. They argue the repeal will instead result in additional fuel costs for consumers to power what effectively will be less efficient and higher polluting vehicles. Not to talk about the health impacts. One analysis by the Environmental Defense Fund, an advocacy group, found that the repeal will result in up to 58,000 additional premature deaths and 37 million more asthma attacks between now and 2055. Even President Obama, who is rarely seen publicly commenting on the Trump administration's policies, said in a statement that Americans will be less safe, less healthy, and less able to fight climate change because of it. Also that the fossil fuel industry can make even more money. The fingerprints of the fossil fuel lobby are indeed all over this administration's climate policy. After funneling billions into the 2024 campaign, the industry has seen a direct return on its investments thanks to the systematic rollback of environmental protections and regulations by the Trump administration. Since the repeal was announced, Trump administration officials also revived the long-debunked myth that carbon dioxide isn't dangerous. Interior Secretary Doug Burgum said CO2 is actually not a pollutant, arguing that plants need it to survive and grow, and the more CO2 there is, the more plants thrive. So what's next? On April 20, the Endangerment Finding's rescission took effect. But like many of Trump's policies, the future of the 16-year-old scientific funding is in the hands of the judiciary. 4 days before the deadline, 16 health and environmental groups, including Earth Justice, the Union of Concerned Scientists, and the American Public Health Association, filed a petition with the EPA urging the U.S. Courts of Appeals of the District of Columbia Circuit to send EPA back to the drawing board. The petition outlines what the groups describe as severe flaws in its rule to appeal the endangerment finding and motor vehicle climate pollution standards. It focuses on the repeal's claim that reducing climate pollution from US cars and trucks is, quote-unquote, futile. The group said that, and I quote, "It's an especially flawed and problematic assertion given that these vehicles are the largest source of climate pollution in the US and one of the largest in the world, and given the clear evidence that reducing this pollution will deliver enormous benefits to American families." They go on to say that the flawed claims in the EPA's initial proposal are based on findings from a wildly discredited report. What they're talking about is a report that pretty much downplayed the risks of global warming, contending that mainstream climate science is exaggerated and overlooks the positive effects of climate change. It was written by a panel made up of 5 climate change skeptics that the Department of Energy secretly formed shortly after Trump took office last year. The petition also identifies how the EPA systematically undervalued the benefits of reducing climate pollution from cars and trucks, and came to the conclusion that the impacts of vehicle emissions are small by comparing them to what they said are phantom numbers and flawed metrics. For example, some of the metrics the EPA identifies do not appear in the sources cited by the agency. In other cases, simple maths errors seem to have led to some wildly inaccurate estimates, as much as 86% higher than they should be, according to the petition. Environmental groups have also filed lawsuits. In March, a coalition of 24 states, alongside a dozen cities and counties, sued the Trump administration, arguing that the rescission was illegal and seeking to reinstate both the finding and limits on standards for motor vehicles emissions. Before them, in February, more than a dozen environmental justice nonprofits, many of which were also behind last month's petition, filed a similar lawsuit. In a statement in response to that lawsuit, the EPA said it carefully considered and re-evaluated the legal foundation of the endangerment finding and revoked it to comply with the law.
The main argument is going to be that this directly contravenes Mass v. EPA. Mass v. EPA decided that this is an air pollutant, that the repeal says no, it's not. That you can't address. The Clean Air Act wasn't designed to address global pollution and global issues. It was designed to address localized pollution issues. And so also that Mass v. EPA said, look, you're not supposed to neglect or decide not to regulate based on policy considerations when it comes to climate change. You need to go through this endangerment process, and your decision needs to be based on a scientific causal relationship. And so naturally, the question of whether Mass v. EPA should be revisited is going to be teed up. And I think that's what the EPA was ultimately trying to do. I think there's a lot of good arguments that can be made that this is directly inconsistent with Mass v. EPA. You can make certainly arguments under the Administrative Procedure Act. This is not lawful administrative rulemaking, that it's arbitrary and capricious. Those are good arguments. However, since Mass v. EPA, there have been significant legal developments. The Supreme Court is considered, a conservative Supreme Court, and there's 6 conservative justices, and they've been more willing to be active in pursuing an ideological agenda that's consistent with a conservative ideology. And there's reason to believe that there may be a more willingness to upset Massachusetts v. EPA or sort of sidestep it altogether. And so these arguments may be received in a different way once it goes all the way up to the Supreme Court. I think it's highly likely this case is going to get taken up to the Supreme Court. And it's not just that there's a different composition on the Supreme Court, it's also that there have been doctrinal changes in administrative law. You have the West Virginia v. EPA decision that says, major questions that are being addressed by an agency need a clear congressional mandate, that an agency shouldn't just decide those issues without direction from Congress. And you could see, based on those sort of doctrinal developments, that the Supreme Court could try to both sort of uphold or say that its decision is not necessarily directly vitiating Mass v. EPA, but that it is somewhat consistent with Mass v. EPA, which did ultimately say it is up to the EPA to make this endangerment finding. So the Supreme Court could try to justify a policy reversal in affirming the EPA's repeal. But in order to do that, it's going to be very difficult not to basically just overrule precedent. But it's definitely reasonably likely that the Supreme Court could do just that. I'll also say that there's a possibility that the Supreme Court could render a new standing finding. The repeal of the endangerment finding also is based on, in part, a finding that the EPA's regulation is futile, that the EPA and its programs can't really make a dent in global climate change. And the Supreme Court may take that and run with it and say, these aren't redressable issues. These parties who are suing really don't have standing because the injuries they're asserting are not redressable through any kind of relief that we can give. These programs aren't going to change anything. Supreme Court could say that. And interestingly, there are the tort lawsuits, climate change tort lawsuits that are now going to be heard by the Supreme Court. And that's one way that those cases could be decided. So I think as the Supreme Court is thinking about this issue, they're thinking about other climate change cases that are currently on the docket. And we have to be thinking about how those two things sort of are, those two groups of cases are going to be potentially resolved.
If the endangerment finding repeal is upheld, We're not just looking at a minor policy shift. We're looking at a fundamental stripping of the EPA's legal toolkit. Noah argues that if the Supreme Court affirms this repeal, the EPA effectively loses its standing to treat greenhouse gases as pollutants at all. Without that classification, the agency's jurisdiction under the Clean Air Act essentially evaporates.
It sort of depends on how a court decides the issues, but I'm finding it hard to believe that if the repeal is upheld, that the EPA is going to have authority to regulate greenhouse gases as air pollutants. It's difficult for me to conjure a scenario where the repeal is affirmed and the EPA continues to regulate carbon dioxide and other greenhouse gases. I mean, it's true that only what's at issue is new motor vehicles, but if the Supreme Court says it's not a pollutant, then it's not a pollutant, and that's the basis for jurisdiction under the Clean Air Act. If the Supreme Court says there's no clear congressional mandate here under Section 202 addressing new motor vehicles, I find it hard to believe that there's going to be some other provision of the Clean Air Act where there is a congressional mandate. So I think that it's going to have to be, if that's the ultimate endpoint, you're going to need Congress to act and to give the EPA authority. And like I said, I don't know that it may be wishful thinking to think that that's going to happen anytime soon. So this may shift the fight to regulate climate change to other branches of government, to other levels of government like states, and to other countries. But this repeal is teeing up a fight that likely will determine whether the EPA has any authority to regulate climate change. We thought that was resolved 20 years ago. As of today, it's really not.
The legal battle over the endangerment finding isn't just about technicalities in the Clean Air Act. It's about a massive shift in how and where climate policy gets made. If the federal government steps back, we're left with a fundamental question. Can a collection of individual states really solve a problem that doesn't respect borders? While blue states like California have already shown that they can move the needle, a patchwork of varying regulations across the country creates its own sets of hurdles, from legal fights over state authority to simple economic inefficiency. And while we wait for a gridlock Congress to potentially step in with a permanent legislative fix, the gap filling continues. To close our conversation, I asked Noah about this complicated future, where the line is drawn between state ambition and federal absence, and whether our current political era is even capable of the creative solutions this crisis demands.
I think it's complicated. I think that, this administration appears to not, to be sort of eliminating climate change from the regulatory agenda, right? I think that depending on how the Supreme Court rules, there could be a huge impact in terms of the EPA not having authority to regulate climate change. I think if the repeal is upheld, yes, the states will be emboldened. And I think there's some limits on what states can do when you're talking about global problems and you're talking about cross-border problems, interstate problems. And I think you're going to see new fights when it comes to preemption. Incidentally, the way the Supreme Court may rule may make it harder for opponents to make preemption arguments. But I do think that if the endangerment finding is upheld, more states, more blue states, more states that have the will and the desire to regulate probably will, and that can make a real impact. I mean, certainly in California, the climate change programs have made a real impact. But when you're talking about a patchwork of states, it is difficult for states to go it alone. So that's why on the federal level, it makes more sense. When you're talking about global problems, it makes more sense to have solutions that are more global in nature, more power to regulate these issues that really truly cross borders. So I think, the DOT and the fuel economy standards will continue to have climate change related impacts. I think that energy efficiency reduces fuel consumption. I think a lot of those programs will continue to exist. And I think that there are some climate risk assessment programs that will continue to exist, and agencies will continue to consider those impacts when making their decision making in their rules. and maybe it's possible, although it seems unlikely in today's polarized era, that Congress could do something. I mean, the idea, there are real legitimate concerns that are raised about courts regulating greenhouse gases, and real concerns about even agencies, regulating greenhouse gases and making those decisions absent, legislation that clarifies what the problem is and what's to be done. And so naturally, what should happen in an ideal government is that the legislative branch would make rules that make sense to address the problems. But what we're seeing is such inability to pass laws and to find consensus that other avenues to gap fill, where you need regulation, that's where you're seeing more creative solutions and attempts to regulate through other means that maybe aren't perfect, maybe weren't originally designed to necessarily to take care of the specific problem, but that have been resorted to. So it's possible that the legislative branches do take up the challenge, but you have to be realistic about this. And what we are seeing today is not a lot of bipartisan cooperation. So that may be something that's not going to happen in the next couple of years, but maybe a few years down the road, it's still possible.
Thank you for listening, and see you next time.